Mr. Kishore, confine yourself to the legal question for reference and not to a particular case, because otherwise it will become a very broad. We are not dealing with your specific.
Conceded. Because this question, that's why I have submitted. I'm ready to assist this honorable court because it's a profound issue. And despite the fact that retroactivity is anathema, if we see the International Convention and Declaration, Article 7 of the Convention of Human Rights, may I request your lordship to go through my supplementary affidavit because I have quoted certain constitution. It's a very brief compilation. That's a very rewarding kind of thing. I would like to your lordship attention on that. Now, my lord, page 12 of my supplementary compilation.
Yes.
Now, my lord, this United States Constitution came about 230 years ago, in 1789.
Yeah.
Right from that time, ex post facto laws were anathema. They were contrary to the rule of law because they violated the values in which the law is rooted. And that is why the very first...
Please, you are in a different scenario. The issue is not that the legislature has enacted something to prosecute you retrospectively. That's not the scenario. That's not the question. Issue is there was a particular provision which gave you protection. The court held that to be unconstitutional for ABC reason. Therefore, I put to you that your concern was that normally a judgment is declaration of law and would apply to all scenarios except in a scenario where the judgment says respectively.
Yes.
But your argument was that since it was a provision protective in nature,
Yes.
therefore declaration of law subsequently should not deprive you of the protection. How I put it. The second question I'm putting to you, not second, but as your submission, as I understand it, that well, on the law being so declared by the court, the legislature in its wisdom decided to cure what was perceived as a defect in the law, which caused the law to be declared ultra vires. And that curing process having taken place, this becomes more of an academic interest. This is the second proposition. Again, I say, have I understood you correctly?
100%, absolutely, my lord. Your lordship perceptivity is profound. Yeah, I said,
Get what you are saying, that's all.
this is my most respectful perception. Now, my lord, can I read page 82 of my compilation, main compilation?
Yes.
Now, this here, I have delineated the emerging principles. As I have culled it out from various pronouncements of this honorable court during last 70 years, from 1951 till 2021, as well as the decisions of the US Supreme Court of Canada, then the European Court of Justice, Supreme Court of South Africa, and various other jurisdictions. And my lord, these are the emerging principles from those judgments. As your lordship just now said, that unless the judgment says that this unconstitutionality which we are declaring shall take effect retrospectively, it cannot take. So this is the principle emerging out of.
Court declares law. Court declares law. If it feels that this law should be applicable prospectively, then it declares and says the law will apply prospectively. That is the principle. Otherwise, it's merely court is not saying prospective, it declares the law. It says this law is good, bad, indifferent, whatever. So, I'm not saying that law will apply prospectively and it will not apply retrospectively is the principle. No. The principle is that law will apply as declared. But the court can, to deal with scenarios which may arise, say this law will apply only prospectively. 140. And please see that you are in a situation where you have a protective umbrella which is sought to be lifted. But there may be far egregious and grievous situations where the methodology of prosecution or who can be is declared ultra vires. Can we say that people who have been prosecuted earlier will continue to be prosecuted and only future prosecution will not be done? How can that be? That cannot be a scenario. So the declared law will apply unless set prospectively. Therefore, I phrase the question, first question in your view was, you felt that this is a law which should be interpreted as prospectively because an umbrella was sought to be lifted of protection which was in your favor and it should not be treated like any other position. One. Number two, that there was a hiatus period because of which when the judgment was in, where the law was what you claim to be in a state of little flux because earlier the protection was there, then the protection was lifted, then the protection was brought back. You say, well, the protection having been brought back by the legislature and its wisdom now, how can what happened earlier affect it? I'm trying to pinpoint these 2 points in the conspectus so that we keep it in the domain. Otherwise, certainly nobody can bring law. All these judgments of courts are for nobody can bring in law. It will be very difficult to sustain it, I would say, if you prospectively seek to prosecute somebody for offences created now. That would be a questionable issue at least. That is not the scenario here. That's all I'm saying.
Lord, that's one respectful submission to your lordship. That when this doctrine of prospectivity came in the Golaknath case, that was the first time in 1967. And in that judgment, they had quoted a number of American authorities and pronouncements in jurists. And thereafter, the Honorable Court came to a conclusion that prospectivity is a valid doctrine in certain situations. Now, thereafter came R.C. Cooper's case in 1970, the bank's nationalization case. And the judgment of 11 learned judges of this Honorable Court ruled that that act nationalizing the banks was unconstitutional. Now, the question immediately arose before the bench as to what will happen to the past transactions. There has been a lot of financial activity. And so the judges, in order to combat that complication, they have mentioned in the concluding paragraph, which I have quoted. So, in case a retrospectivity is desired, that has to be expressly stated in the judgment. That is the law, not the prospectivity. If the judgment is silent, for example, in Subramanian Swami's case, the judgment says it is invalid. It does not say it is void. There is a difference between voidity and invalidity. Void means empty space. It does not exist. It has disappeared. Validity means that that thing is existing, but it is not operational or enforceable. So the law exists, but it is not enforceable because of the finding by the court. So it can be revived, just like a person lying on a ventilator. So the law is under ventilation and it will be revived. So, my lord, in that judgment.
Law doesn't remain ever on ventilation. Law is as it exists and recognized. That's
Lord, if a law is declared as unconstitutional,
then there is that law doesn't exist. That doesn't exist on paper.
That law remains on the statute book, but it is not enforceable.
It doesn't remain on the statute book. I'm sorry. It doesn't remain on the statute books. Once it is struck down as invalid, it stands as if it never existed. It stands obliterated completely.
So, on that, I would like to quote 3-4 authorities.
Do that.
With due respect to the lordship's perception, I will quote few authorities on this. As to what is
any authority, show me any authority which says even after declaration of law as invalid, that law continues to remain on statute book. That is what you are saying. Please tell me if it says so. We are always in a process of learning. I am willing to learn.
नहीं दे दीजिए इसमें से कंपाइलेशन दे दीजिए 5 कंपाइलेशन जज साहब को दे दीजिए 5 का सेट है ना इसमें 4 वाली
We will look at one compilation which has been filed and the 3 compilations.
Without the judgment of the USA, Canada, France,
Law
let
development in
people-
India has been so much. Why do you keep going to all over the world?
Oh, okay, it's not argument. Then I don't sign it.
Yes.
I don't sign it. But I will only.
So sure to us from the law developed over the last 70 years that the proposition is that once a law is declared is invalid, it still continues to be in the statute book. That is what you contended. Please show to us one judgment of this court.
Yes. So I will.
Either one judgment is good enough or 20 judgments are not good enough.
Yes, yes, my lord. I'll cite two judgments of this only.
Correct. This you have categorized as prospective overruling. This volume which you have given us is prospective overruling, which shows prospective overruling can take place. Certainly,
Yes.
you are saying there is an implication that any law which is struck down is only struck down prospectively, without saying. So this is what I understand your
Mentioned in the judgment that it will take a retrospective effect. And this is mentioned in the judgment that this unconstitutionality which we are declaring will have a retrospective effect. That is what Cooper says. R.C. Cooper says, I read. Lord, there are 60 of my, page 60 of my compilation, you would like to watch. Page 60 of the first paragraph on this page. In accordance with the opinion of the majority petition, petition number so and so are allowed, and it is declared that the banking company's acquisition and transfer of Undertakings Act 22 of 1969 is invalid, and the action taken or deemed to be taken in exercise of the powers under the Act is declared unauthorized. My respect to submission is that by this judgment I have learned that if retrospectivity is desired, that has to be expressly stated. This is the message flowing out of this judgment. That is why I made this submission. Otherwise, there is no need to add this clause. Once they say that that act is invalid,
We can't read a judgment like a statute. The difference between a judgment and a statute. You have to construe the logical meaning of the language of the judgment, which says that it is declared that the banking company's acquisition, transfer, and undertakings act is invalid.
yeah.
Now, once it is declared invalid, the court went on to explain, says the action taken or deemed to be taken is there. Once it is declared invalid, anything done under invalid law is bad. That's all.
We can't read into this judgment and saying that till we declare that earlier actions were invalid, that's not, the judgment will be always prospective. That's not the issue of this judgment. That's not the ratio of this entire, which is flowing from this judgment.
Below.
So, sure, that's why I said your best case forward is only this, that this was a protective measure available to you. And since the protective measure has been declared as ultra vires on a principle of discrimination, and the legislature in its wisdom brought it back with removing the discrimination and in fact expanding it, it should not be lifted in the interregnum period. This is the only argument which I feel can be made subject to whatever is.
Below, one more.
Yeah, and one more thing you must remember, once court holds that law in Constitution, the Article 13 clause 2, it becomes void. It becomes void.
That's
So you can't say that a law which is declared as void will continue to be valid for a specific period, though it is in violation of Article Part 3. You can't say that.
below. Below, in that respect, I made a very respectful submission with all humility.
We are also conscious of the anomalous situation which is flowing from it, that there was protection earlier, then there was no protection, and there is expanded protection again. It's not that we are not conscious of the scenario which emerges.
It was continuously changing. It was in a flux, coming and
They were in a flux. I'm sorry. They were in a flux. It was a protection available till the court said it's discriminatory in character. Because it is discriminatory in character, it was cut down. So it got removed. But then the legislator removed the discrimination, brought it back with an, if one may say, an extra vehemence by expanding not only to all kind of officers, but also giving protection to retired people. So it was a larger extent. Therefore, I don't know how many cases are there, only for the interregnum period would remain. Most of the other scenario would be over because the protection is available. After that, the new protection came in, that protection is available prospectively. The protection which was earlier was there, as you said, many cases would have availed of that protection. Correct. But at some stage, between the judgment in Subramanian Swami's case and the new law being into force, there was a little hiatus period of time. And the complication arising from that hiatus period of time, we'll have to deal with.
that is the, during that hiatus, the law was different. Before that, now it is
The same, you are right. You are right with that.
So for that historical hiatus period, all that has been granted earlier, all that has been undertaken earlier, cannot be erased. That does not stand obligated.
As my brother put it, it is difficult to say that a law which is treated as violative of equality and is discriminatory can be held to be only applicable prospectively. It's difficult, especially it's not said. So it will be very difficult to say. But let us say that we understand the problem and try to see what is the why media to be found out of the problem, where a law is declared unconstitutional as violative of Part 3 on ground of discrimination. That discrimination is removed by the legislature and a new law brought into force. But in that process, some 3 years elapse. That is it.
That is the situation. Now we know just few lines more, just few lines, just few seconds. Page 59 of my complaint.
Yes.
Second paragraph on page 15. It is also unnecessary to examine the further argument. This is the case of Madhava Menon 1951 Supreme Court.
We are reading now page 60.
59.
1951
Yes. Yes.
SCR.
No, what you have page 59 refers to R.C. Cooper.
The second, just
A.
before asking-
Madhava Menon versus the state of Bombay.
Just above it. It is the next.
So I am reading one of the paragraph from the judgment which I have quoted here.
Oh, so you are reading actually what starts at 57.
Yes. I am reading which starts from 57.
You're reading part of that.
Yeah. So I can read it from page 57 itself.
No, read it from 59. I was identifying what you are reading.
59, page 59, second paragraph. It is also unnecessary to examine the further argument of the learned Attorney General that in case since 1868 in this country, the rule of construction of statutes is the one laid down by Section 6 of the General Clauses Act 1868. And that though, in express terms, that statute may not be applicable to Article 13(1) of the Constitution, yet that is a rule of justice, equity, and good conscience, and has become a rule of common law in this country, and should be applied even to cases where statutes become void by reason of their being repugnant to Constitution.
Sir, this judgment will not apply. This is under clause 1 of Article 13.
13(1), 13(2), 13(1).
Difference between 13(1) and 13(2).
Yeah.
13(1) will apply to a law which was very much valid till 26th of January 1950. Because there was enactment of Part 3, it became unconstitutional.
That's right.
And in that context, the entire discussion proceeds. But we are dealing with 13(2), where a law is enacted when Part 3 was in force.
Milo,
That's the difference between the two, 13(1) and 13(2).
Milo.
So this entire discussion in the context of 13(1).
That context also.
Because the Supreme Court says here that that particular law was valid, even tested on the basis of 1935 Government of India Act.
Sorry, that is a factual scenario of this case.
And the other proposition is.
But subsequently,
That's
subsequently, A.K. Gupta 1997,
Deals with law which was valid till
it
26.
becomes a part of the common law, therefore it's.
subsequently in 1997, A.K. Gupta versus the state of UP, that also I quoted. They have said that while interpreting the unconstitutionality of a statute, no distinction can be made whether the law under challenge is the one before introduction of constitution, that is whether it is under Article 31 or 32. The same principle will apply to both, because Article 367 does not distinguish. Article 367 of the Constitution says that the General Clauses Act shall be applicable to the interpretation of the Constitution, just like it is for the interpretation of the statutes. And that has been quoted by A.K. Madhava Menon in 1951. And that led me to think that since General Clauses Act grants immunity to the past transactions, and the Honorable Supreme Court says that General Clauses Act is applicable to the interpretation of a constitutionally void particular statute, so that led me to think. Now I am reading the relevant paragraph of A.K. Madhava Menon, 1951 Supreme Court. This is para 58 of my compilation.
Yes.
Para 58, page 58,
58.
page 58, para 2, the quotation. The High Court took the view that the word void was used in Article 13(1) in the sense of repeal, and that consequently it attracted Section 6 of the General Clauses Act, which Act by Article 367 was made applicable for the interpretation of the Constitution. Then another paragraph of the same judgment. Persons, now I'm reading on the same page, page 58. 1, 2, 3, 4, 5. I'm reading fifth paragraph on page 58 from Madhava Menon's judgment. Persons during the continuance of the statute obtain rights under it cannot be affected by a declaration that the statute with effect from a certain date will become an inoperative statute. Necessity of introducing a saving clause, it does not need the aid of a legislative provision of the nature contained in the interpretation of the General Clauses Act to hold that a prospective declaration that a statute is void affects pending cases is to give it indirectly retrospective operation, and that result is repugnant to the clear phraseology implied in various articles in Part 3 of the Constitution. When a statute has been in operation, say for 50 years, people have suffered penalties under it or have acquired rights thereunder. The law has been enforced by courts, and for such a long period, then to say that when it is repealed, it is obliterated and it never had any existence and was never passed in Parliament is rather saying too much and is ignoring hard real facts and amounts to shut be more consistent with reason and justice to say that the law existed and was good at the time when it was passed. So, my lord, this is what the message flowing out as a young.
That's all. Again.
And as I said in the beginning, my lord, in view of the affidavit filed by the Union of India, so my case,
We are conscious of
they are not challenging the judgment of the Honorable High Court. They have conceded that the judgment is fully consistent with law. So this appeal is unfounded. The appeal does not survive because the Union of India is answerable for the actions of the Syria. And shoe motor notice was issued to Union of India by this Honorable Court. And Union of India said that they are not interested in contesting it because the judgment is fully consistent with law. Where is the illegality in the judgment, impugned judgment? So why should we contest it? So what remains in the appeal against me, my lord? That's why I submitted that for me, as far as I am concerned, it is of academic interest. My appeal does not survive.
Thank you.
Thanks, my lord.
Who is next in the line for you? Where does it arise?
I am in your lordship's hand because I was
Doesn't-
already because
No,
I announced that
see,
your lordship wanted to
my,
go into the question.
being the final court and being a constitutional court, I think it would not be advisable also to get into academic areas. Because then what happens is some things are, law is created on economic.
I have only come since the court on this question.
So really speaking, if you can bring it within the four corners of the question reference made, it's fine. But if you are going to expand it and not within the four corners of the reference made, why should we go?
I think it won't be fair for me to even attempt because your lordship, the reference is only on.
That's what I thought.
Say, and I don't think it's proper for me to expand and try and stretch an argument.
You can enjoy your vacation in Delhi.
I'm sorry.
You can enjoy your vacation in Delhi.
Yes, who's next? Yes.
Say.
It is wrong. My lord, as a lordship rightly put it, there is a practical difficulty getting it from courts. That the law is valid for a particular amount of time, and then it's declared invalid. And courts in England, courts in India are all grappled with the question, what happens to that declaration of the law? Now, the difficulty arises where the judgment is silent on its operation. If the judgment says that this will operate, it will not affect past acts, it's all right. But the judgment doesn't say so, then what happened? That is a major problem. Now, my lord, the point arises because of the use of the word void in 13.2. That's how the problem starts. And if your lordship sees 31 and 32, I'll just give a broad outline of what I'm going to submit and I'll come to you with the points. When the draft legislation was being made, they said that insofar as pre-constitutional laws are concerned, to the extent they'll be consistent with party, the law shall stand abrogated. The word used was abrogated. That's furtherly consistent in basic capacity and abrogated. But insofar as post-constitutional law is concerned, they use the word, the extent of inconsistency, it will be wide. Ultimately, in the meeting of 8th October 1947, when the final draft was made, 13.1 and 13.2 both use the word void. Now, the legal jurists, Sir William Wade and English courts have held that the word void and void are voidable, are imprecise terms. And the difficulty of using the word void in a public law statute is that we mentally try to bring a concept of contract law into the concept of void ab initio and so on. However, the difficulty arises because in the judgments that are given, when the lordship declares 6A to be invalid, what is the impact of the judgment? Does it mean that 6A was never valid from the date it was enacted? Does it mean it was invalid from the date of the declaration? Or is it possible to have a wide area where the courts have now introduced the concept of the second actor, theory of the second actor, where by a declaration, the law is invalid. I'll come to obliteration later. The law is invalid. It is invalid in law, but it exists in fact. So there are articles which I have set out and well recognized articles saying that this is the metaphysics of validity. In law, there is an invalidity. The law is not there at all. But in fact, it was there. Now, how do you solve this particular problem is the main question. And there is one gentleman of the English court which recognizes this problem. They say for England it doesn't arise, but for countries having written constitution, this should be a practical problem which the courts in that country must resolve. That's the problem. Now, what has happened is this. The question referred to is in the context of Article 20, in the context of immunity. Now, I will submit two basic questions arise. If your lordship holds that the protection of the 6A was in the nature of an immunity, was in the nature of a protection, then will your lordship read that protection into Article 20? I would further go to say that 20 should not be read in isolation. 20 should be read with 21. These articles go together. So, reading 20 and 21 together, 6A is an immunity, and as lordship rightly pointed out, 6A did not come in 2004. From 1969, we had a single directive where you could not proceed against people above joint secretary records certain prior approval. That was literally valid but invalid by being on the ground. You can't do by a directive. There is no statutory provision. How can you do this by a directive? Then they introduced an ordinance. Then they introduced the act. Lordship see from 1969 to now, last 55 years, except one period of 18 months, this protection always continued. This protection always continued, and I have put it in my mind. Now, when this immunity is taken away, will Subramanian Swami then say that from 2004, if it is invalid, if it is obliterated, quote unquote, the law never existed. What happens to all those cases where the sanction was granted, not granted, etc.? That is the problem the lordship has. So there are two parts to it. One is the lordship holds that 20 relative 21 grants an immunity, and that immunity cannot be taken away retrospectively. If that responsibility, if that protection could not have been taken away retrospectively by the legislature, can be interpreted as judgment to take away that immunity responsibility. That's from the context of 20. And then the larger question, if the lordship wants to answer it, I leave your lordship. I am going to request the lordship to hold my humble submission that whenever the court declares a statute to be unconstitutional, it is my humble request that the lordship, based on the law, that the court declaring the law to be invalid, maybe the High Court, maybe the Supreme Court, could also point out what will be the effect of its judgment. Because there are so many cases where the whole thing is completely unknown. I'll just give an example. In Tamil Nadu, if your property rent was more than 400 rupees, rent tax protection did not apply. You have to go for a civil suit. That law came in 1960, section 10(3)(3). In 1986, the Supreme Court struck it down saying that how does it make a difference? Every tenant is entitled to protection, violative articles. Now the rent act of 1960 struck down in 86. If a lordship is obliterated, never been accepted, what happens from 1960 to 86? Take a criminal law, Mitchell's case. Did not the IPC said if you are a right convict and you commit, then death sentence is mandatory. Honorable Supreme Court held that this is completely unconstitutional. You can't say that the person serving life imprisonment is a separate class and therefore deserves no mercy at all. That was struck down. Now, 302 was there in 1860, IPC. Struck down in 1983. What happens? So, my lord, this is called rightly mentioned. There could be different considerations in a taxing statute, different considerations in a welfare statute, different considerations in a criminal statute. So, the point they are making is, wherever the law is intended to protect, preserve fundamental rights, if there is some taking away of that right, it is challenged. And if a lordship then strikes it down, as the general rule, the liberty should go from the beginning, is my humble submission. But if it is creating some impediments, and it is retrospective, that also should get retrospective. But if I am getting some protection, say for example, suppose there is a law which says that if, unless your income is more than 3 lakhs, you should not be punished. Suppose the court strikes it down. Then I would say it is prospective because all along people, smaller SSCs will not be prosecuted. That is the law. So, the Lordship Commission shall I take 23 first and when you go further? Yes.
Whatever you want.
Yes.
That's why I did mention that or also that while interpreting, we'll have to see what is the consequence of a protective law which has been struck down. It will be different from a prosecuting law which is in struck down.
Yes.
One. Number two, if a protective law is struck down, some consequences may arise and you feel that the consequences should normally be enunciated by the court while striking down the law. Worth examining. The second aspect is also that why it was struck down. In this case, and honestly it's troubled me, it's struck down because it is discriminatory intent. So violative of Part 3 as brother wrote. But that discrimination is removed by bringing in a new law into force. The legislature also in its wisdom thinks that protection should be there. But since it granted protection to only a particular class of people, it says now we'll widen the protection, remove the discrimination, and go it beyond even the retired people. So, when that law comes into force, it will have application from that date of the law. So, people who may be falling in any of the categories will get protection. Now, there is a hiatus period, you say that was 18 months or 2 years or whatever it is, when till the law was enacted and it was struck down as how should the court read it?
Correct.
This is why I'm posing it is because I think you can you should endeavor to answer this conundrum and see
Yes.
and assist us. How should an interpretation like this take place?
In fact, I think lordship, so please, Lord, I think because every time the judgment is struck down, then what happens? And I'll also deal with this question of obliteration. In fact, when I was talking to Mr. Desai before he was saying that this kind of protection to civil servants is there from beginning. It's not that it has come with a single directive. The IPC had the provision of sanction, criminal procedure for that sanction for very good. The idea is the public servant should not be harassed. If it's a thing, he should not be subject to direct police inquiry. Some filtration mechanism should be there.
Also, were we to agree with you, how should it be done? What is this?
Yes, I will give you. I've written a lot of research on this.
It's difficult per se to say. This is why I put Mr. Difficult to per se that if a provision is struck down, it will not apply retrospectively is very difficult to accept. It will apply prospectively if it is said so. Otherwise, it will apply. The law will be obliterated. Prima facie is subject to voting. But there are, as you said, there are different nuances. What happens when a protective law, that too on a criminal side, is removed? And removed why? Because it is discriminatory. This is what it is discriminatory, and that discrimination is removed. To some extent, it is academic in character because it's possibly arising only how many cases of those kind are pending now, which were within that window of time between the protection being granted. In that sense, government is not really so much
But they
concerned.
didn't give an affidavit. But what I thought is the lordship decided a constitutional question. And it goes back to the regular bench, then not that bench to deal with that issue. Because they gave an affidavit that in this period there are 197 cases, in 110 we gave sanction, we didn't give sanction, etc. And the court wanted that particular bench, it came first before the two judge bench before they reported it. They didn't have it. And lordship is one very subtle point lordship can ignore. What happened when the lordship declared a statute to be unconstitutional? My humble submission is that the law is not taken away from the statute because what the scholars have said is removing a statute once is a function of the legislature that can be done only by repeal. But you will see, you normally repeal a statute, you omit a section. Suppose the main act continues and you omit certain provisions, then there is a omission of that section or repeal of that particular section. When a whole statute is repealed, we use the word repeal. What the courts have said is the court merely says this section, this statutory provision is ultra virus part 3. It need not be part 3. Today it can be a violation of 265. It can be 286.
Declaration of law. That's
It's constitutional limitations. They give constitutional limitations. And the further difficulty, as my friend also pointed out, your lordships for the last 60 years, we just don't have express fundamental rights. We have got derivative rights now. So many rights have been written to 21. My lord judgment in privacy, where is privacy? Not sure there is privacy. So we also have got derivative rights. Now,
and we've also said that these rights evolve.
Evolve.
We can't today specify what
Yes,
it is
yes,
because
yes. So I want to see the article 20. I'm going to make some submissions because I'm saying, please see article 30. It says the extent of contravention, it is wide. Now, what is the meaning of the extent of contravention? Lawrence writes in his book, he says the constitution can be taken to two ways. It is self-operative. The law is violating Article 14 is what I am issued. Now, it could be egregiously wide. Suppose we tomorrow say that any person below the height of 6 feet can't apply to the police, you strike it down. It's egregiously bad. But suppose it's a law which requires interpretation, which requires consideration. Now, 6A launch asked the question, why was it struck down? The referral order said, referral order didn't talk of classification. Referral order said, can we strike down a law on the ground of arbitrariness? That was a reference to the judgment in many states. The referral order which Subramanian Swamy was there was only on the ground that the arbitrariness can be a ground for striking down the law. But ultimately the bench struck it down on classification.
on discrimination.
Yes. The Farhided bench can strike on a different ground. There's nothing wrong with that. So that's how it actually went off. Because in the arbitrariness was answered in Shire among face in a different situation altogether. So please see Article 13. Let's start with Article 13. No, major only has some written submissions.
Views.
Yes.
Mr. Datta has written some.
He began well by saying that I will start downstairs. Decided by the power on one body. If you the council will be occasion. It could be if you stops.
Yes.
Yes, but although the only one question has been referred, I have submitted the three question in address, the P lordship to permit charge and determination, because I think now with this, a lot of clarity is required on the point. What is the effect of declaring a particular judgment as unconstitutional? So this is the lordship.
That in any case, in some way will arise from it.
Yes,
There is a,
Yes.
what you are saying is a consequence.
yes.
We are also looking, when we look at prospective, retrospective, the consequence will have to be looked into.
And I think if your lordship wants what I didn't know how to expand it, there is another side angle, what is retrospective, what is retroactive. They want to clarify that point also if you later, because the effect of such a judgment on action taken or omitted to be taken during the period when the law remained in operation, and whether there is a difference between a law held unconstitutional for lack of legislative competence and a law held to be unconstitutional for violation of Part 3 or other constitutional limitations. Now, I'm going to go to 21. Now, what you kindly see, 21 reads as follows. No, I'll finish the argument on 20, then I'll come to 14 and 13. 21. No person shall be convicted of any offence except for a violation of a law enforced at the time of commission of the offence, charged as an offence. Lordship will just mark the thing there. I'm saying that 20 is in two parts. One is no person shall be convicted, and second part, not be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of conviction of the offence. So my humble submission is 21 can be read basically in two parts. The first part is the pre-punishment stage of the trial stage leading up to conviction. And the second part is post-conviction, that is, what is the punishment inflicted, which can only arise if a person is found guilty. Now, when I read the judgment of Justice Mathur on Transaction Corporation when it was in, his lordship said that 20 grants immunity from ex post facto laws. We traditionally understand ex post facto laws to mean that you can't increase the punishment. If the punishment was 6 months, it can't become 1 year. But is that the limited scope of 20? Does 20 go beyond that? Is the question put by the Honorable Supreme Court, which was referred. And my humble submission is, though conviction means conviction of an offence, if you lordship see the marginal note of Article 20, which I didn't reproduce here, it says protection of 20, marginal note says protection in respect of conviction of offences. Protection in respect of offence of conviction. Now, can we say that the word protection in respect of conviction will mean not only the conviction should be as per the law enforced at that, but the first part of 20 in bracket 1, clause 1, will include all the procedural safeguards that are available to an accused at that point of time. And I am supported by Justice Matthew's judgment, which says that 21 should also take place only by following the prescribed procedures starting from inquiry, investigation, trial, etc. If the first stages are not permitted, unless there is a specified prior rule, there is immunity from prosecution, and there can be no conviction either. This immunity is entitled to protection under Article 20 in bracket 1. The marginal note refers to protection in respect of conviction. The words in respect of must be interpreted to grant protection to all existing procedural safeguards at the time the offence was alleged to be committed. See so and so. 6A thus creates an immunity or grants a protection and cannot be taken away retrospectively, either by a retrospective amendment or by a judgment declaring such immunity invalid. It will be paradoxical to interpret 21 so as to create an embargo on a statutory provision, which is statutory retrospective provision, but permitting such deprivation by a judicial order. Not so we just put statutory provision.
Mr. Datta, 1 minute, please. Just come to the section 21.
Article 21.
Just read it slowly. The first portion, not the second portion. You're not concerned with the second portion.
Yeah, Lordship is that.
Issue of law and force. Now, this does not talk of procedural law. If the procedural law violates Article 21, clause 1 does not deal with, it's very specific. It is very, very specific. And it may have its extreme consequences, what you say.
No,
One minute.
if we got
So this really is talking about the substantive law under which you are convicted. Correct? As far as procedural law is concerned, now one may say, why shouldn't this procedural protection be granted to several other cases? right not to be disturbed is still not recognized fully in India, but indirectly it's now whether we can bring it under Article 21, right not to be disturbed, is a question which may arise in some.
Correct.
It will arise. It's bound to arise with the law which is expanding. So, therefore, we have to be very careful when you're expanding that doctrine to include procedural law. But it's not to say that procedural law should not be fair, because that if it is unfair, it may hit by Article 21, right not to be disturbed, or under Article 14 on the ground of, to be careful on that.
May I respond? Lordship is right. If you read it, literally, it's only a substantive law. But a question mark was posed by the Honorable Supreme Court in Translation Corporation.
We'll deal with it, but
No, you're absolutely right. It only talks of conviction, not ask for further particular living material. That would be relevant only for considering the question whether the ground is vague or not. Now, Lord, para 21 is very important. And see the spirit with which they read 21. The facts of the cases might induce mournful reflection how an honest attempt by an authority charged with the duty of taking prophylactic measures to secure the maintenance of supplies and services essential to the community has been frustrated by what is popularly called a technical error. We say and we think it necessary to repeat that the gravity of the evil to the community resulting from antisocial activities can never furnish an adequate reason for invading the personal liberty of a citizen, except in accordance with procedure established by the Constitution and the laws. Now, please note, this is what I am stressing. The history of personal liberty is largely the history of insistence on observance of procedure. But it bears reading once again, beautifully put. The history of personal liberty is largely the history of insistence on observance of procedure. And observance of procedure has been the bastion against wanton assaults on personal liberty over the years. Under our Constitution, the only guarantee of personal liberty for a person is that he shall not be deprived of it except in accordance with procedure established by law. The need today for maintenance of supplies and services essential to the community cannot be overemphasized. There will be no social security without maintenance of adequate supplies and services essential to the community. But social security is not the only goal of a good society. There are other values in a society. Our country is taking singular pride in the democratic ideals enshrined in its constitution. The most cherished of these ideals is personal liberty. It would indeed be ironic if in the name of social security, we would sanction the subversion of this liberty. We do not pause to consider whether social security is more precious than personal liberty in the scale of valuation. For any judgment as regard that would be but a value judgment on which opinions might differ. But whatever might be the impact of maintenance of supplies and services in the community, when a certain procedure is prescribed in the Constitution or the laws for depriving a person's liberty, we think our duty to see that that procedure is rigorously observed, however strange this might sound to some ears. Petition guy to release from custody. So, my Lord, I would humbly request your Lordship, since it is coming now, for interpreting 21 with 21, 20 in bracket 1 with Article 21. To say that the provision, no person shall be convicted, that process of conviction must take into account both the procedural safeguards and the other substantive safeguard, is my humble submission. And I would say don't read 21 isolation, though Justice Mathur doesn't refer to 21. I would request your Lordship that the para 15 of the Transportation Corporation Order, I would humbly request my Lord to say that scope of 20 bracket 1 must be read along with the right under 21 itself. If 21 is a source of derivative rights, yeah.
Really speaking, these observations are with reference to Article 21, not with reference to Article 22.
No, but the point is,
What? Number 2. These are two separate. Yes, there is an interplay between the rights. There cannot be, cannot say there is no interplay between the fundamental rights. But Article 20 is a very specific nature of protection. And whatever you are arguing will not get diluted whether you bring it under Article 21. But to say that the police should not have any power of investigation or inquiry should be read into as a basic right conferred under clause 1 to article 20. By reading the provisions of article 21 into 20 clause 1, we will create a lot of issues and problems in a given situation.
No, I appreciate it, but I'm only submitting.
Because when we lay down the law, because rights under Article 21 are certainly protected, those have not been taken away. And one cannot say the sanction is a protection given under article or inquiry or investigation which is done by a third party, that's the police, because that's where the society, because the very fact that investigation is done by a third party, not by an individual, is a protection.
And Mr. Datar, one more thing. 21 takes care of the procedural part. If procedure is arbitrary, that Article 21 protects you. And therefore, Article 20, Clause 1 remains confined to the substantive law. Because reverse regarding procedure is taken care of by 21.
It may create a lot of issues.
That's right.
It will create a lot of issues because like 1973, the code changed. There have been amendments also in the Prevention of Corruption Act with regard to substantive, with regard to the procedural part from time to time. Because certain amendments were made in 1988, if I'm not mistaken.
But I'll put it this way. I would humbly request the Lordship not to read 20 and 21 in separate silos. This was done in A.K. Gopalan, and we have got the masterly descendant of Fazal Ali, who his Lordship explained very beautifully what happens if you start taking articles in separate silos. One of the finest descendants, Fazal Ali, is Fazal Ali. Now, I would submit to this bench that an interpretation which advances personal liberty should be preferred to an interpretation which tries to reduce or restrict personal liberty. Now, my humble submission,
We are not saying what is being, we are not saying that these have to be read in separate silos. What is being pointed out as the procedural part is concerned is protected under Article 21. As the substantive part is concerned, it's protected. It's a very, very specific protection which is given against penalization or criminalization of past acts. It's a specific protection against which bars penalization of past acts, which will not offense at the time when.
Correct. No. So that's the whole part. In fact, in one of the seminars at Bhopal, Mr. Venkatram Reddy put a very interesting question. He said, Article 21 is a procedural right. How are you using it to derive rights from 21? That's a very interesting debate. 21 only says no person shall be deprived of his life or liberty except under procedure established by law. How do you get right to housing, right to road, right to Article 21? But the point is, this is where constitutional interpretation matters, where the court doesn't go by the literal language of 21 and say that, look, 21 simply says no person shall be convicted. It is only confined to substantive law. That is a very literal reading. I am requesting, as Honorable Supreme Court in the Translation Corporation said, please see page 122 once again, madam. Please see page 122 once again, because this is very critical. It all depends how your Lordship is going to view it.
No, Mr. Datar, you are right to the extent that we have to uphold a liberty.
An interpretation which promotes liberty.
No difficulty on that.
Yes. Yes, sir.
All right, you have to go back to
No, you must have saying something I didn't.
No, in any case, there you are right.
Yes.
The question is, if you are protected under Article 21, should we expand the scope of Clause 1 of Article 20?
Yes.
That's the only question.
Yes, my only submission is yes. I am submitting that it should not be convictions. I am discussing with Mr. Amit Desai, most in law more than perhaps more than me. That when you talk of conviction, one literal way is conviction means conviction of an offense. This is an offense you are convicted. That's the end of the matter. Now, the Supreme Court says, should we rethink it? They go to the various international developments. They go to how the US Supreme Court has interpreted ex post facto law. What is ex post facto? Is it just punishment? Is it just this, or is it also question the safeguards? That's why they say deprive the accused of any substantial right or immunity possessed at the time of commission. Will not immunity be a procedural part also? And also, I'll argue, as my friend pointed out, the word law in Article 13 partly, law includes substantive law, procedural law also. Why should we restrict law to mean only a substantive law is my humble question. So I'm just submitting what the Supreme Court has asked us to consider. It's time, this is now 70 years have passed, let us reconsider the scope of 21. Lordship will kindly see, or deprive the accused of any substantial right. My lord is right, substantial right. Or immunity possessed at the time of commission of the offence. Now, what is the immunity possessed by an accused? Immunity can be below 5 lakhs, don't prosecute it. That's an immunity. Now, you can't say even below 5 lakhs from retrospective.
That will form part of the substantive law. Let's say, like in the Income Tax Act, for late filing of the return, is a stipulation 1 lakh, which has continued from 1976. That's a different matter because it should have been increased. For late filing or non-filing of return, there's immunity till 1 lakh. So that obviously is a part of substantive law. So even if we delete that section, obviously the past offences will not be covered by it. That's part of immunity. What immunity? What you are referring to here is a procedural investigation, because mere investigation or inquiry does not lead to either. It's a process of investigation. It's an embargo. It's a bar on investigation. It's a bar of investigation. It's not a finding. So really speaking, the provision here, what you are saying is do not investigate, do not inquire.
6A says that.
6A says that.
I am requesting my lord to say.
Can you say it's the bar of investigation and inquiry will be covered by Article 20, Clause 1?
I am only submitting that when you talk of 20 clause 1, it simply says no person shall be convicted. And that's submitting. If a person has got an immunity from being prosecuted unless you get a prior approval, what does clause 60 say? If your rank is more than joint secretary and above, and that was from there from 1969, you got the Santana committee, all people have said, let public servants not be harassed, therefore they issue some filtration process. They put a cutoff at joint secretary. Why? Because decisions are taken at the joint secretary level, which has got economic consequences. That's the logic. Now, my only submission is, I am only requesting the lordship to construe 6A as an immunity. 6A as an immunity.
From conviction.
No, from investigation inquiry at the very first stage itself. And that's what also discussed in Veeraswamy case, which I'll come to later, because why in Giri Karan they said there is no inconsistency between Veeraswamy and Karan 28 and this. One of the questions referred was, is there an inconsistency between Veeraswamy's case and this case? But students on the answer, there is no inconsistency. So I'm not getting into that aspect. I'm only submitting what is the meaning of immunity. If a lordship takes the Hofelden aspect, right corresponding is duty. Immunity is the opposite of privilege. Lordship takes Hofelden Q. What is immunity? The jural corollary of immunity is privilege. But here it will not operate. In fact, one way we have addressed this article, partly doesn't contain only rights, it contains privileges, it contains immunity. So I am only submitting that ultimately lordship has to decide when you are giving an immunity to civil servants, that if you are above the rank of joint secretary, you will not be subject to inquiry investigation without the prior approval of the central government. That should be taken as an immunity, and that is entitled to protection under 21. Now, the judgment of Justice Matthew, up to para 20, he goes into the aspects of government detention, the civil supply, their diverting some essential commodities, etc. Then he comes to 21, and 21 is a passage of universal application. Not simply 20, because the judgment is in the context of what it decides. But there are certain passages of the judgment which go beyond the particular judgment, they go into the human values. And there, they go bring that and expand the whole scope. At least in the dissenting opinion in Jabalpur, idiom Jabalpur. From Magna Carta, they go to and say this ultimately, what is the liberty? The liberty is a compendium of substantive rights and procedural rights. A liberty can't be taken as substantive right. if I have got procedural safeguards, if I am above the rank of joint secretary, one filter is there, go to central government approval. So I made my point, I leave your lordship to see how your lordship wants to interpret it. Because look at the other way of looking at it. A person has got immunity for all these years. Forget Subramanian Swamy. Suppose 6A had given this immunity and Parliament wanted to amend the law retrospectively. I dare say that it would be a very strong case for me to argue that this immunity was given to me from 1969, made it into a statute continued for 10 years. Now in 2014, forget the Supreme Court, suppose Parliament in 2014 said no, 6A is invalid from 2004, retrospectively amending it. I would humbly submit that the Supreme Court would strike it down, not only on grounds of arbitrariness, but on the grounds of 20 subsection 1, clause 1. You could not have even started the trial with the joint secretary. Where's the question of convicting him? And therefore, I am asking you the protection in respect of conviction. In respect of lordship interpreted in all liberally. Now, if a marginal note, generally not important, but if the lordship is interpreted 20 for the first time, which is the direction we want the country to go? Are we going to say 20 is just restricted to substantive law? Or is it time to say 20 encompasses all the immunities, all the protection? I would say immunity, a better word would be protection. Safeguard. These are all synonyms of immunity in the context of Justice Mathur has said. So immunity will mean safeguard, will mean protection. All these things are part and parcel of the 21 right. Take it as a prosperity, nobody says no.
What you are saying, Mr. Datar, is
Yes.
that where a court would load to uphold the retrospective action of the legislature, don't give an interpretation where the court would be doing the same.
Yes. So until a judgment can't violate Article 14 after Budho, this Viraskar's case. So there was a small deviation until but that's a different. So this is my subject as far as it is. The subject to what Leonard AG says, this is a strong statement. And I'm only submitting. I didn't want to come to the lordship. If your lordship gets time, just see the judgment of Justice Supreme Court in Translation Power. His lordship starts at page 116 and then kindly come to page 117. Because his lordship starts reflecting what is this ex post facto law. Please come to page 117. Now, see para 7, section 9 of Article 1 of the US Constitution as interpreted, of this as adopted on 4/7/1776, provided that no bill of attainder or ex post facto law shall be passed, and section 10 of the same article lays down that no state shall pass any bill of attainder or ex post facto. The import of this constitutional guarantee was explained 2 centuries ago by the US Supreme Court in Calder vs. Bull, and lordship will just see item number 4. Every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of commission of the offence in order to convict the offender. Now, legal rules of evidence. Why not we take it as protection also granted? I'm not talking section 25, 26, statement made to a police officer, etc. I'm saying the ex post facto laws, if it can go to protect legal rules of evidence, why can't it protect other immunities also granted?
You after lunch take us to anything else, or you would like to, from your note, you will take us to something?
Yes, I'll take a note. So I'll just go to now, post lunch, I'm going to go to the effect of the lordship declaring under 14. Is it void ab initio, still born, etc.